Everybody here knows me, but if you don't, my name's Randy Litz. I'm the mayor of Hamiota Municipality. And we're very grateful today to have some people come from water stewardship to talk about some of the rules and regulations and share some information with us as far as the do's and don'ts in the process and all kinds of fun things like that. So I'll introduce Ingrid Rothney. She's a senior water resources officer, and Haley Nelson, who's kind of, most of you probably know Haley. She's the boots on the ground person in our area. So without further ado, I'll turn it over to them and they'll lead us through the presentation. And if you have questions afterwards, we can look at answering those. And also, if you have specific questions, they're more than willing to kind of sit off to the side and take those concerns or those questions from you, so it's not, you know, airing dirty laundry or anything like that. And I will say that I've chaired some of these meetings in the past, and I do know that I always put a disclaimer in that you can get a lot further if you act more professional, if you have a professional attitude towards it. That water is one of the most contentious things in not our area, but all over the province. And so rather than go up to your neighbor and start yelling and screaming, or starting with them too, I think you get a lot further if you try and share the information and then deal with it kind of in a more professional manner. So I won't take any more of your time. I'll just turn it over to the ladies here. And
Good afternoon. As Randy said, I'm the Senior Water Resource Officer for the western half of the province, and just wanted to welcome you guys here. We just wanted to take some time and provide some information to everyone. We'll go through the process of applying, some complaint information, enforcement, and we'll touch on some tile drainage as well. And we'll just start, and we'll switch on and off, and then, like I said, at the end we'll have more than enough time for any questions. And like I said, we'll stay after if you have specific questions on specific files or locations or anything like that. So we'll go through the overview of the legislation and some of the regulation changes. We'll touch on the no net loss of wetlands that we have. We'll also do kind of a registration versus licensing, which one you will need. We'll go through the application process, the complaint process, approvals that you'll need, and enforcement. So Drainage and Water Rights Licensing Branch, we basically administer and we seek compliance with the Water Rights Act as it relates to water control works and water use. So water control works include surface and subsurface drainage, dams, dikes, filling, pretty much anything you can think of that deals with diverting or holding water. The Water Rights Act states that no person shall control water or construct, establish, or maintain any water control works unless he or she has a valid and subsisting license to do so. So amendments came in October of 2019, seeking a new streamlined approach for lower risk, lower impact works. It also had enhanced protection for wetlands and modernizing inspection and enforcement tools, including enhanced penalty and enhanced offense and penalties. So, we are excited to share that the proposed concepts of this new amendments include a new approach to exempt certain works from authorization from the department, a new registration approach to 6 types of projects, a streamlined approach to focus officers' attention on higher risk, higher impact projects through the traditional licensing process, added flexibility to downstream landowner sign-off requirements, and a new approach that requires compensation of more permanent wetlands. So the good news is we have exempted certain activities altogether from requiring any authorizations from our department. In the regulation, there are specific cases where the proponents will not have to come to us for authorization under the Water Rights Act. Those exemptions are same for same culvert replacements, as long as the culvert is the same size, same location, and put at the same invert elevation. Any project that requires approval under the Environment Act does not require approval under the Water Rights Act. And water control works within an urban center. So basically, that used to be an old policy under our department. This is just more a formalized one. Works within an urban area, which do not outlet outside of that urban area, or propose the loss or alteration of class 3, 4, or 5 wetlands are exempt.
So I'll get into the no net loss of wetland benefits approach. So in the new regs, we included the newly proclaimed act requires compensation for the loss or alterations of certain wetlands. So this regulation further describes steps towards achieving a no net loss of these wetland benefits. And the mitigation approach is based on a hierarchy of avoidance, minimization, and as a last resort, compensation. The amount of offset required will vary depending on the type of restoration or enhancement work being done. So we only offer this for class 3 wetlands. So if you have a 4 or a 5, which are your more permanent, those do have to remain in place. You can't alter them in any way. So this just goes through the different wetland classes. So class 1 and 2 are your ephemeral and temporary wetlands. So these are kind of like the nuisance ones that are there in the spring and go on within a week or two. Sometimes if we have a wet year, they'll hold water a little longer, but not usually. They're usually cultivated or tilled. It's the same thing. Or seeded, sorry. Now we're getting into the class 3, 4, and 5. So seasonal, semi-permanent, and permanent wetlands. You can kind of see the pictures, but not overly. The regulation outlines that class 3 wetlands will require mitigation in order to obtain a license to drain them or alter them. Pervious to the policy, we will continue and will not allow for the drainage of class 4 and 5 wetlands. The regulation will allow for the loss or alterations of class 3 wetlands if mitigation measures are met. So there is four mitigation options. So the first one is compensation at a 2-to-1 ratio. So it can be made to Manitoba Habitat Conservancy, and it's 6,000 times 2 times the amount of acres you have. So for example, if you have a 2-acre class 3 basin that you wish to drain or fill, they'll take 6,000 times 2 times 2, so that's $24,000 that would have to be paid to MHC before we would issue you your permit or license. And we calculate the average size of the basin by looking through all years of aerial imagery, and we do it outline and then we average it. So it includes both wet and dry years, not just wet year. Number 2 is to restore or increase the area of an existing class 3, 4, or 5 wetland. This requires a separate application for a license, which includes a plan that must be submitted and approved by the Director of Drainage and Water Rights Licensing. And it's at a 2-to-1 ratio. The third one is to provide permanent legal protection of wetland enhancements within the same watershed at a 3-to-1 ratio. So this requires a plan set out with specific enhancement actions to be completed. The legal protection document must also be submitted with your application for it to be approved by the Director of Drainage and Water Rights Licensing. And then number 4 is to provide legal protection of prescribed wetlands classes 1 and 2 within the same watershed at also a 3-to-1 ratio. So those also must be submitted to the Director of Drainage and Water Rights Licensing for approval.
Okay, so the new streamlined regulatory approach will allow for certain types of routine works to be registered with the department. provided that the applicant adheres to the regulatory standards. So more extensive works that do not fit into those 6 classes of registration works, they have to go through the licensing process. So registrable projects, there's various types of drainage and water retention projects. Sorry, it was 7 classes. Essentially, if it fits into the one, you can do the registration process, but it has to fit all those regulatory standards, as I said. It is the $100 fee for those registrations. And the department will provide the proponent with a registration certificate within 14 days if there's no other reason to stop or hold it. Reasons for stopping or holding it may be that the officer needs to inspect it. That might vary a couple weeks to a month depending on when that application was submitted. Just know that projects that are registered through that system are usually audited for compliance to ensure that you've met all those regulatory standards as well. The licensing process, like I said, if it doesn't fit into that registration, it has to go through the licensing process. And we strive to provide licenses within 6 weeks, but it's all depends on how busy an area is, how busy an officer is, how complicated the file is, if we're waiting for information, all those different kinds of things. Okay, so there are a few things that cannot be registered. One of those is any kind of works that result in the loss or alteration of a class 3, 4, or 5 has to go through a licensing. The results in the transfer of water across a watershed boundary, results in negative impacts on fish spawning, rearing, or passage. This situation usually triggers an Environment Act review, so you may have to get a license through that instead of through our Water Rights Act. If the project is inconsistent with an approved watershed plan, which is usually done by your local watersheds, and if it results in the violation of a conservation agreement. So I'll just start off and kind of do a brief description on some of the registration classes. The first one is the minor surface drain reconstruction or construction, where depths do not exceed 12 inches, and that is from prairie. That is not 12 inches from what it was or what you did the year before. The second is construction of subsurface tile drains, where works have a drainage coefficient equal or less than 3/8 over a 24-hour period. These all projects must also be designed by an approved tile drainage installer, and they must not be located within 50 meters of a class 3, 4, or 5 wetland, and must meet a couple other technical conditions. C is construction of new access crossings that do not constrict water flow. In these cases, the applicant has to demonstrate that the project will not result in a constriction of flow. So that's usually done by providing information on downstream and upstream culvert sizes to show that what you have proposed in that access does not constrict the water. D is replacing an existing culvert with no more than 15% change in hydraulic capacity and no change in the invert elevation. We usually see these in some of the older culverts where they don't make that size anymore, or it was an old boiler pipe. Sometimes it's old cement square, some of the old ones you see. If it's just a change of less than 15% in that hydraulic capacity, it can go through this. We just, in that case, you would have to provide us with a little bit of survey information to show us where that invert elevation is, and then we would be able to issue a registration certificate. E is works that restore or enhance wetlands that are no more than 1 meter in height and retain less than 25 acre-feet of water. We normally see these kinds of projects through your watershed. They're usually the ones that are proponent, or MHC or DU, these are those projects. And F is construction of dams less than 2.5 meters in height and less than 25 acre feet of water stored as well. So the last one, G, is construction of dams less than 1 meter in height and less than 25 acre feet of water storage potential that has continuous flow. So it does not hold water permanently. In the last three classes that I mentioned, additional approvals from landowners that may be flooded or may see a reduction in downstream flow because of the dams would have to provide approval.
So we'll just go through an example for you guys, and we chose tile drainage as the example. So for a registration, you just need to ensure that all aspects of the project on the application meet the requirements for a registration. So that's about the coefficient not being within the 50 meters of a wetland, making sure that you're following all those rules. The registration certificate will be issued to the landowner with a copy to the contractor applying on behalf of the landowner. And the registrar will contact if not registerable. So say you have a tile that is too close to a wetland or it's going through another landowner. Sometimes blind road allowances, people don't realize that they're there because they're farmed and they look like it's just the farmland. That's when you'll be asked to either submit another application or fix the one you have to not include that area, etc. For a license, so if your registration, if you don't fit into the parameters of a registration, then you'll have to apply for a license. And the works on a license, so say you have land and it's all one landowner and they're touching from either side to side, corner to corner.
Wait till you speak up, please.
Yeah, I can try. So say the land is either corner to corner, up and down, side to side, touching in some way, shape, or form. You can put those all on the same license. Yeah. Perfect. And I'll just switch this. So this will be a little harder to read for you guys on the screen, but it's basically just going through like the registration versus licensing for tile drainage. So for depth on average with the diameter and spacing of your lateral pipes, for registration, it needs to be equal to or less than 3/4 of an inch over a 24-hour period. For a license, it's the same. Okay. Anyways.
But yeah, it just goes through every one of them, just basically showing that if you don't meet it on a registration, you can meet it in the licensing.
You would just amend your
Yeah.
project or application. And then this is just your tile plan requirements. So a tile drainage plan that consists of like aerial photographs or maps depicting where the extent or the location of the proposed projects requires the legal land description, and the location of any roads, drains, wetlands, or infrastructure related to the project. Where the outlets are, the number of acres being tiled per outlet, the 24-hour coefficient, the location and type of outlet, so there's gravity or there's control structures or a lift station, the outflow rate in gallons per minute per outlet, the name of the designer, because for us to check to ensure that that's an approved tile designer, we have a list that we double, triple check, so that's the only way you can do it through registration. And then the date the tile drainage design was designed, and then just a KML or KMZ of the network so we can look at it on our maps. So this is just an example photo. You can see there's the main, which is where all the laterals lead into. So the black lines on the picture are your lateral, so those are your perforated pipe. Then the colorful one that you see that goes from pink to green to blue, that's your main. So that's normally non-perforated because that carries the water to the outlet, and the outlet is marked and it says outlet location. But this is what we look for in a tile design. So when there's a tile project that's going to be installed and there's groundwater concerns, and if groundwater is encountered during the installation, or if the project is to be sited in a sensitive area, we do require a hydrogeological impact report. The report will contain technical drawings showing the location and extent of the proposed works and the route proposed from the point of entry into the existing drainage system to the point where the discharge would enter into established waterway or water body, like a drain, creek, river, lake. Additionally, the applicant may be requested to provide pre and post development discharge calculations to prove that the discharge rates have not changed and will not result in a negative effect on the downstream landowners or the infrastructure that they're draining into.
Okay, we'll just go through some little, couple slides on how to actually apply. So any questions on how to apply can usually be found on our website. Pretty easy to figure out, www.gov.mb.ca/drainage. So that should get you a lot of your answers. This site includes educational materials, links to relevant legislation, Manitoba Ag Maps, directions for applying, and branch contact information. So once you have actually gone to the site and actually created an account, once you get into that account, you can actually view all past licenses you have or any current ones that you have done, and it will show the status of where they are. Also, if you'd want more assistance on applying or questions on the application process, there's a lot of how-to videos on the site as well on how to do things, how to create a user account, how to apply for a water control works license registration certificate, and how to apply for a water use license if you need it as well. And as always, if there's more questions, we are always able to answer. So application fees. So in 2019, in the amendment, they did up the application fee to $500 for a license. But as Haley mentioned, if you do have contiguous land that is touching each other, you can put all those locations together on one license. If it's the same landowner. The registrations are $100. The only one that can do multiple locations is a municipality. They can actually do several sites if they were doing one application for, say, 10 new crossings, right? Or 10 new approaches in a certain area. They could put those all in one. But it's more we see it more being asked from the landowner's point of view. How many applications do I really have to put in? So we are actually moving to incorporate best practices from other jurisdictions that have addressed the challenge of balancing the needs of the landowners, seeking to improve drainage with the mitigation of effects on downstream landowners. So under the old regime, projects could be delayed based on objections that are unrelated to downstream impacts of the project. Your dad sold my dad a bad bull back in 19 whatever and led to, continued strife between families, etc. And a lot of time that's still carried over to water control and drainage projects. So the registration process will require sign-off from the immediate downstream landowner. If the downstream landowner won't sign off on a project and the proponent feels that it's unwarranted or unmerited, the proponent can contact our officers and prior to submitting their application to review the project. If the officer determines that there is no impact from the works and that you would not require that downstream landowner, we can provide a written exemption that would allow you to still apply for that registration process without having that required downstream landowner sign off. In license cases, the applicant is required to provide sign off from those parties that are significantly affected by the proposed works. So the officer will assess the application, and if they will determine if there's any additional sign-offs that are required. If you've said, okay, I think my next neighbor might be affected by this, and you have his signature, and we deem that maybe the next one as well needs it, we will let you know that. So municipal approvals. AMM members had a wide range of opinions on the need for municipal sign-off when we were doing the amendments. In the end, it was determined that the municipalities had the power to create a customized drainage bylaw so that they could review any projects or a subset of some drainage projects within their boundaries. Our licenses will be clear, though, that other approvals, including municipalities or other provincial acts, will be required. If the municipalities want to make us aware that they have a drainage bylaw, we will advise our clients specifically that there is one and that they need to go to their RM to receive it. So timelines. Everybody always asks us, how long is it going to take? Because I'm doing it tomorrow or the next day. Like we said, for the registrations, it's usually 14 days unless we can get it to you earlier. If we've reviewed it, there's no issues, we have no concerns with it, we can give it to you before that 14 days. So that is an option. 6-week turnaround for licenses. This is a benchmark, like I said. It is dependent on the officer's caseload, their files, weather, time of season. If it's 3 feet of snow and we can't even see the field, there's really no chance we're going to do a site inspection. So, and it also depends on whether or not you have all the required documents. If there's a sign-off you need, or if we're waiting for something else and that's on you and you've been told that and we're waiting, then yes, it could be significantly longer than 6 weeks.
So I'm just gonna go over the water licensing portal public map. So this is a good spot to go if you guys wanna know if, say, you have a license or your neighbor has a license, because if you can see that picture, it's a little blue and hard to see. But there's lines all over that quarter. So that would indicate that this landowner has a permit or license for drains on their land. Usually if it's tile, it'll be a whole whack of red lines. With this one, it's just like random, kind of following the natural lay of the land, so that would just be drains. Usually red dots mean culverts. A purple dot is normally a complaint or water use. Purple hatching on the field is normally water use as well. But this is a good resource to use to determine if authorization has been provided to a landowner and can assist in determining whether what is viewed on the landscape is authorized or unauthorized. So now I'll go over the complaint process. So it is preferred if complaints are submitted through the water licensing portal so they can be looked at as soon as possible. Normally if you send in a paper copy, it has to be mailed to Winnipeg and then they manually put them in, so that does take a little bit longer, and some of our complaints are quite sensitive. But however, if you are having issues using the portal, moving forward, you can contact your local officer in this area. It's me, and I can provide you with a paper copy of the complaint form that you can fill out and mail to Winnipeg. We do need complaint submissions to be as complete as possible so we know what is occurring. So on a map, print out an aerial map and draw on that what you're seeing or what is impacting you. Who is doing it, if you know? Where is the offense occurring? When did you see it happen, or when did you first notice it was constructed? And if you're able to take photos of the offense and include them with your submission, that is also super helpful when we go and look at it. Because 9 times out of 10, I've never been to the field, so it's just kind of a guessing game on where you're going. You can find it on a map, but if you're at the north end of the field and I'm at the south, I wouldn't really know that unless you put in a picture to show. And witnesses should know that their complaint forms won't always be anonymous, as witness statements may be required if the complaint results in enforcement. So if it goes to, say, a municipal board hearing, that's normally when it comes out. For that reason, complaint forms should be filled out by or on behalf of the witness to the offense so that the witness statement can be taken. In the case that it ends up going to court or the information submitted on the form is unclear, it is helpful to be able to contact the person witnessing the issue directly so that we can clarify the information, and it just gives us more information on what's occurring. So now we'll go on to enforcement and the public. So the public's assistance in notifying the department through the complaint form process when they are being impacted by unauthorized drainage is encouraged, sorry, can't read today. If you don't fill out a complaint form, we can't really go and look at the complaint. So if you fill one out, it gives us a paper trail to be able to do that enforcement and write the orders or tickets if we have to go to a municipal board hearing and get those works mitigated, closed, fixed, what have you. So then we go on to compliance. So the branch will often take steps to achieve voluntary compliance, so we try to work with landowners rather than punish them. We understand that farming is busy and not everyone always has leeway with time frames. So we try to work with people to get things fixed. It can often be very effective without the use of enforcement, but say we send you a letter and you don't comply with it, and we post an order and you again don't comply with what we're asking, it's kind of hard not to enforce on a landowner. Officers have a few different options when it comes to enforcement. So we have a warning or enforcement notice that we can give you that day to basically tell you to stop what you're doing and either apply or put it back. A ticket, which the fines actually have recently increased in related to the Drainage and Water Rights Act. I don't know what they've increased to though. Or we have long information, which includes a mandatory court appearance with fines up to $50,000 for individuals and $500,000 for a corporation, and or 3 months imprisonment. And we also have a ministerial order. So say a landowner, so ministerial orders. These provide the minister with the authority to make an order in case where unauthorized water control works are occurring or have occurred. So we require, when we post an order, we require the landowner to remove, cease, repair, or reconstruct the water control works. So we're basically telling you that you have to put it back to what it was. Service of the order can be completed by personal service, registered mail, leaving a copy with an adult, or posting it on the land. So that's how we get you your order, so we know you've received it, so you know the dates and when you have to comply by that. If the person fails to comply with the order, an officer or a person authorized by the minister may complete the works outlined within the order, and any costs incurred to carry out these actions can be recovered from the person to whom the order is against. So as a water resource officer, if you don't comply with the order that was posted on your land, I can hire a contractor to go and complete the works, and then we bill the cost back to you. Any appeal of an order must be made to the municipal board within 30 days of the issuance of the order, and the decision of the municipal board is final and not subject to further appeal. However, it may be noted that the appeal does not stay the order, so the required works within the order are to be completed by the landowner or through hiring of a contractor by the department while the appeal is still pending. So if you're still waiting to be heard at the municipal board hearing and your deadline passes, we can still hire a contractor to fix the works if you do not comply with the order. So if you guys have any further, or if you're looking for any further information or need help, you can either email either the /drain, or go onto the /drainage or water use for more information, or you can email drainage@gov.mb.ca or wateruse@gov.mb.ca, Or you can contact your RM and they can give you my contact information and I can try to assist you guys. Anyone have questions? Yeah?
Just kind of a two-part question, Haley. You said alteration of wetlands. What if the landowner doesn't want to get rid of water, or he actually just wants to deepen it so he can hold water in a more condensed area instead of flowing up to the sides?
So in that aspect, you would still be altering the basin, and wetlands are pretty sensitive. So if you dig them out, you actually end up destroying it because they need to have the proper substrate, thank you. So that would require authorization, and that would be kind of the whole increasing the size of the basin. And it's not just digging it deeper, like you have to go through and make sure there's proper slide slopes and an inlet and an outlet, and it's not just as easy as digging it out.
Okay, and a spin-off on that, what if somebody wants to build a brand new dugout that's maybe in a lower spot to catch more runoff?
If you're talking like, say it's like 1 or 2, like how we described class 1 or 2 wetland, if it's in that part, we would have no issue with it. If it was a 3, 4, or 5, then we would probably have to have a discussion, definitely.
So there need to be a registration on a class 1?
Possibly, yes. I think that would be a case-by-case basis. Just looking at exactly where you want to put the dugout and where that wetland is, or things like that. Yeah.
It wouldn't really be a one-size-fits-all for the wetland stuff, because each one varies depending on where you are.
Right.
Yeah.
You mentioned urban areas are exempt. Does that include retention ponds and dams within urban areas?
Yes, unless you're outletting outside of it, or altering the 3, 4, or 5, then it can be exempt. So it's, the Act has the municipal statute for the list of villages and towns, and we go by that one. And so if your town or urban area is located in that list, then it's okay. But some of those towns and villages have changed in the past couple years. Some of them are no longer considered towns, or some of them are no longer considered villages, so you have to go by that list to make sure that your urban area is included in it, so that you can be excluded or exempt from it.
Yeah.
Who's responsible for removing beaver dams from a natural gunway?
The landowner.
Usually the responsibility falls back to the landowner.
And what if they don't do that?
Well, a lot of cases, we basically ask them, or ask whoever's worried about it or impacted by it, to see if the landowner would be willing to let somebody else in to do it.
We can't force someone to remove a beaver dam.
Yeah, it would take quite a bit for us to be able to do that. We just advise to work with the landowner and try and see if they'd be open. Maybe they don't have the funds, maybe they don't have the machinery, maybe, like, it could be any number of reasons why they can't do it. But if they're willing to let somebody else in to do it, that's usually the best case scenario.
And what if that don't work?
I'm not sure.
Can you use a ministerial order?
So a beaver isn't considered, like, beavers are natural, they're an animal. We can't control them, people can't control them, so they're not technically unauthorized works because it isn't human done or human made. It's an animal. So our
Yeah.
order wouldn't compel to that because it's not unauthorized works that's created by a human.
Yeah.
It is a beaver.
It's a little sticky, definitely. I believe there may be a municipal, something in the Municipal Act we've heard of that allows the municipality to go in, possibly.
If you're causing damage to somebody else, I would assume
Yeah.
there should
So,
be some teeth.
Or
to
is it
that.
conservation? There was one through.
I don't know.
Oh.
so yeah, that may be something worth looking into if that is a real concern at the moment.
So a landowner can clear a beaver dam on their own, but like, they can just go out and clear a dam if it's on their land.
Yes,
And if it's in the RM ditch and the culvert, the RM have the right to go and clear it at all times.
yes, it's
But
their
just the
infrastructure.
RM,
Yeah, yes.
is that correct?
Or the RM can allow, that's their, like, if it's their land, they can allow you if that's part of their process.
Okay.
But we cannot tell you or give you authority to go into the RM ditch and clear up beaver dam.
But the RM can say yes, and it's up to them.
It's up to
Yeah.
them, yes, not us,
Yep.
yeah. But yes, if there is something, it's, yeah.
Yep.
Landowners, you have that right.
Okay.
We usually advise to
Be wary of the time
timing.
of the year.
Yeah, right, making sure nobody's got bales down, you know, along the creek bed or something, right? Make sure you're not flooding somebody out, or if they still got crop and, you know, it might bust out something, right? Just being good neighbors,
Best
usually,
Practices.
yeah. Anybody, when?
Okay, I'm a landowner and I have a parcel of land and I rent it out and my renter commits an offense. Who's getting served?
The landowner. We can't go after the renter. We only can do like orders or letters to a landowner. Because ultimately it's your responsibility, your land is your responsibility. So if unauthorized works are undertaken on your land, it's your responsibility to either close them or fix them or license them. You're welcome. Any other questions?
Any questions about any of the registration process? Over, Ed?
You mentioned municipalities have drainage bylaws. How many in the western region have them? How many municipalities?
I would say not many, actually. There's a few. It's getting more prevalent, definitely.
I think out of the RMs I cover, only 2 do.
Yeah. Some of them have specific, say, tile drainage bylaw, and then all other drainage bylaws. Some of them are both. Yeah, it's hit or miss, actually. I don't think there is a lot. Yeah, I don't think you guys do, right?
No.
It just makes, for a municipality, it just makes reviewing and approving or denying them much easier, right? You've already got set bylaw out and you know exactly what you're looking for or not looking for, and so it does make it easier on the RM if there's a lot of projects that outlet into a municipal road allowance, so.
Can I drain, say, a pothole on my land from one pothole to another one?
Depending on the class, so if it's a class 3, 4, or 5, no.
What is a 3, 4, or 5?
So if we just go back, so class 3s are your temporary wetlands, so those are normally the ones that'll hold water into, say, June, July. You normally seed around them. In the dry years, you may be able to go back and seed them, but they're normally dry by August. Those ones are a class 3. You can't combine them unless you have a license to do so. 4s and 5s are your more permanent. They normally hold water almost all year round. You're normally always seeding around them. Unless it is super dry, like I want to say 2020, some 4s were seeded. But if it's a semi-permanent, temporary, or permanent wetland, no, you would need authorization or to talk to us. And then we could tell you for surely yes or no, but right off the hop, I want to say no.
If it's any one of the 1s or 2s, so your smaller, your less permanent ones, if you're talking about draining one of those, say, into a large open water wetland, it would still be some kind of process. It could be a registration process. If the drain that you're going to dig between them is less than 12 inches, you could do it by registration. If it's going to be more than 12 inches, you might have to go through the licensing process.
What about cattails?
What about them?
them?
Can you remove them without a license?
Yes, if you're cutting them.
You can't move the soil.
Like if it's the floating ones that are up top, that float along and float along.
Yeah, you can remove them if you're just like, if you're scooping them out or mowing them and collecting them. I don't even know what that machine is called, but kind of like a hay vine kind of thing, cuts them and you can do that. There's no license or authorization is needed for that.
Unless there's dirt work.
Yeah. Were there any questions on the registration versus licensing? Everybody clear on the difference between the two? Or which one you might need? We did set out some
Paper copies.
paper copies of basically what is a registered work. Laura has them back there if you haven't already grabbed one. It basically sets out the regulatory requirements of each class of works. So you can look through that and know if your project is one of those classes. Tile drainage. It's definitely moving in this area. Any questions related to that? I would just say if you're looking to maybe not do a full project, maybe just want to do a couple tiles for some low areas. If you're installing them yourself, you would have to go through the licensing process. If you are going to get an approved tile drainage installer to do it for you, they can go through the registration process.
Can I take one of those small potholes that holds water early in the summer, and then it eventually dries, it's full of rushes? Can I drain that into another existing slough on my place, like a larger body of water?
If the one that you want to get rid of is not a class 3, 4, or 5. If it's a 3, you would be able to drain it, but you would have to mitigate for it. And that's where compensation or enhancing or any of those other mitigation options, those would be what you would have to do. If it's a 1 or a 2, a class 1 or 2, yes, like we explained earlier, that could be something we could authorize. And
If you're only allowed to dig a ditch 12 inches, you said?
Yeah, under the registration process,
Right.
yes.
But so if you want when would you want the tile drain then? Like how
Sorry?
deep, when would you want to actually tile drain something?
So,
How would you allow this area to tile drain? Because like you want to you put a tile 4 or 5 feet in the ground, right? So you're going through a hill, so you're draining 5 feet deep, right? You know what I'm trying to say? Like
Yeah,
if you've got a pothole here and a pothole in there, you've got 5 feet hill,
yes.
you can drain that to there now, right? If you put a tile in.
Yes, you could, yes.
So how can you do that but not have a surface ditch?
Because the process is the registration process. If you can do it, you can't do it, yes, by registration. You can do it by license.
Okay.
Yes. I mean, we don't advise a 5-foot ditch or a 6-foot ditch.
But like
Usually-
still just a class 1 or 2 wetland?
Yes.
Yeah.
Right, yeah.
Yeah.
Yeah, okay.
Yeah.
and if you guys ever have issues with like classifying wetlands, you can always reach out to me and I can assist you with that. And you can just tell me the corridor that you're looking at, and normally using aerial imagery, I've gotten decently okay with classifying them, and if you need a site inspection, I would meet with you.
If you complied.
Yeah, if you've applied.
Can you switch to the other screen with the 3, 4, 5?
Those ones?
Would it be safe to say if there was cattails as a class 3?
No.
No. I would say if you look at it and there's more like bulrushes, so like not a cactus, but the circular ones that are darker green, or if you have the plant that has yellow flowers that you see sometimes, or water plantain. It's normally looks like plantain but has a stem with a lot of white flowers or purple. Those are kind of indicative of a 3.
If you're talking more 4, you're obviously gonna have a little bit of open water usually in the 4s.
I'm just thinking from a farmer level, it's maybe easier to identify classes on our own property.
Yes,
Find
there,
species of the same.
yeah, absolutely, and there is educational on the website, and I believe DU has a guide on how to classify them as well. And you can look up, our regulations actually state that, you know, a class 1 should have these types of plants, a class 2 should have these type, and so if you can look up those plants and you can try to identify them. That's what we do when we're on site and in the field. We go and we look at what the plants are telling us.
I'm pretty sure there's a key on our website to follow too, and it's like,
The
does it
right
have
key.
this? And if it's a yes, you go down to the next one and then over.
Yeah.
So what's the process for me to get you to come out, take a look at my property?
In what aspect? Like, you want to do drainage, or you're not sure about what to do, or?
Yeah, that's right, I'm sure what to do.
Basically, I think at that point, you'd have to propose something, right? Propose at least something, and then we'd be coming out to inspect it, basically to look at it.
How much that cost me?
Well, if it was a license, it would be the 500. If it's the registration, it would be 100. Because we're really not in the business of telling you what to do, right? Like, as in telling you you should drain this or how to do that. We're saying yes or no to what you want to do, right? You're telling us, I want to do this, and we'll say if we can authorize it or not. So it's really about what you think you could do or should do or want to do, and then coming to us, and we will work with you on getting it authorized if we can.
So that would be $100 or what would it be, $100 on that?
It might be if you're just proposing something like a surface drain that's less than 12 inches, and you're saying, I just want to drain this little pothole into this big one. That might be something where we would be coming out to look for, you know, because we're not sure what that pothole might be, right? You're saying it's probably a 1 or a 2, so we would come out to confirm that, usually.
I send in an application to do a job, you come out to inspect it. Is there an inspection fee?
There's no inspection fee. The inspection is part of your application. Yeah. Yes.
I have a very basic question. It would appear to me that any time there is an application for more water to come into these drainage projects, there must be some serious consideration about culvert capacities. I heard you mention culverts, but how can any water be allowed in if there are inadequate culverts? And who decides what's adequate, what's inadequate?
So basically, if we're talking culvert sizes, those are usually municipal works, right?
Well,
That's
I'm saying for 40 years, we've had culverts that are inadequate. And that, I don't know how any application can be considered without first looking at culverts and the capacity of the waterway. I've never heard how that plan is made available. It's maybe top secret, but I think we should know about it.
Well, we don't have a plan. There's no plan. Yeah, we don't have one. I don't know if the municipality has
You
one.
don't have a plan for capacities of a waterway? You
Like-
don't know what culverts should carry or is designed to carry?
Well, we know what a culvert is designed to carry, like what their maximum carrying capacity. Yes, we know that.
I think we should know what the capacities are so that we have an idea whether our location of our land makes us a wetland because the water can't get away. And culvert capacity can let the water drain quickly from one area, but sit in another for 6 weeks. And after 6 weeks, there's no point in trying to seed it if there's water land.
Yeah, so most culverts are municipal infrastructure. So if there's any type of concern related to culvert capacities, like that they're not enough,
But how could somebody come in with a request for drainage without that being applied against culvert capacities and say, hold it, we can't get the water away, so we have to increase culverts before we can approve that request?
yeah, so usually that's part of the assessment, part of the application process.
It shouldn't be an application. This should be something that any application for request for drainage should automatically be applied by whomever makes the decision to do it or not do it. It shouldn't be up to the landowner to check the culvert capacity.
No, and it's, I mean, the landowner's probably best, they're gonna best know that, right? They're there all the time usually, right? They're gonna know that, they're gonna see it, they're gonna see that it overtops, or they're gonna see that it's full all the time, or maybe it doesn't run anything. Yes, you will best know that.
Other than serious backflooding, I would say that the culvert capacity problem. Now, if you're thinking we don't have backflooding problems, then you're not aware of the reality. And it's time those sort of pragmatic decisions were looked at.
Yes, and so when an application is assessed, and any kind of proposal outlets into a municipal right-of-way or road allowance, we go back, or you go to the RM to say, is there any concerns here, right? Does the infrastructure, can it handle it, right? Is it backing up? Is it going over the road? Is the culvert at full capacity already? Those are questions that we are asking, or we are asking the RM to tell us.
Shouldn't you have to know that when somebody puts in an application and says, I want to put more water into this waterway? If the culverts are inadequate, that should be an immediate no, it won't go, because the culverts can't handle it. So first we have to upgrade culverts.
Yeah, there are certain areas within the province that do have that. There are already. But for us to know that of the whole province, there was no way we could do that.
No.
We would not be able to know that.
We've already brought this problem forward to this RM, to yourselves, many years ago, and we have continuously brought it forward and get to work.
Okay. You've submitted a complaint through
We have come forward with your predecessors, we have come forward to the RM, and the RM has done nothing, you have done nothing, all we get shoved off to the one side, we'll do nothing about it.
So-
And nothing has ever come forward.
So what was the decision? Like what was told to you? Like what decision was made?
One, the predecessor Barb Kingdom has been moved from one, I brought it up with her.
Okay.
This lady here, I brought it up with her. Now you go getting on, and you've said here 6 weeks for a license, the RM needs to clean out their shit to get the water to move. We're told they're not allowed to fix the cattails or anything else. The RM needs to do their work to get the water moving through your land.
Okay.
We're not a water
It's
park.
not just one RM. You can't just all of a sudden increase the flow and say the next RM downstream, too bad for them. It's a concerted effort that has to be done politically. A lot of this sounds like political patronage, not design. And that's no way to deal with the situation.
No, we are aware that unfortunately in the past, there wasn't the best design for infrastructure, right? A lot of times it was put in a culvert, whatever you had in the yard, right? Whatever was available, whatever, like, right? If it was an emergency or you just, no offense, but slip something in, right? Just to get it through or get the water
We
moving.
have an illegal problem crossing the main CNR line. And it's been there for decades. And yet the solution has always been dodged around. It's a bottleneck there. That's just before the next municipality.
Yeah.
But that something has to be handled. You can't everybody point the finger at somebody else so you forget about it.
Well, keep sending plenty more water down, do more licenses north, and you can't get rid of the water in the south. So to me, does it not make sense to start in the south and work north?
It does, son, yes. It's gonna be whoever's going to propose something, whoever's gonna propose a change, or to propose any kind of works, and then, yeah, the best case is working downstream to upstream, absolutely.
But Randy, I had you out and you seen my land flooded. You seen it. Yet we're no further forward this year than we were last year. What do you propose we do this year?
You can't keep permitting more water to come in and all these fancy permit regulations. And if you know you can't get rid of the water in a reasonable time, what does it mean? Sometime you gotta say, we gotta fix the problem, we can't let more water in.
No, and there are, like I said, there are certain areas in the province where there is, I don't know if I want to use the word moratorium, but there is kind of a hold on any permits or registration certificates going to a certain area, but that was dictated or requested of the province by the municipalities.
It would appear logical to me that when an application comes in, the first thing somebody has to do before they even take it any further is say, is there any reason we can't proceed because of a restriction in the whole network? What's the point of nitpicking about one area when you know the whole system can't carry the load?
No, we're aware, that is a concern.
Solving
Yeah.
the wrong problem. You've got to start with the top of it. And grandfathering doesn't answer it. Just because people have had the good fortune or smart to drain 40 years ago, doesn't mean that there can be no way to get the water away from the downstream side. The whole pathway has to be considered as one system.
Absolutely, and we're open to hearing any proposals that you have to fix any downstream issues.
I need to explain why, if you look at any of the design of culverts, capacities, why upstream culverts are bigger than down. Anybody with any idea of planning a system would know, as you go downstream, there's more and more land being drained. They should get larger. Have a look at our systems and you'll find that's not the case. Glaringly not the case.
Yeah, and there is some instances, definitely, we've seen them. And it usually, I want to say usually, it's a landowner concerted effort towards the municipality to get those changed. So we have seen that. But that would be, again, that would come through the application process. We would look at that basically and what you're proposing to upgrade those culverts to, what capacities they're holding, if that's enough, if the downstream are not enough, and that's part of the assessment process that each officer does. Sorry, back.
So, when you come into these situations where you discovered like a backup or something like that, do you let the RM know and give them any suggestions on how to fix it?
So we wouldn't actually give any suggestions, because that turns out to be like, I'm telling you what to do and then I license what I'm telling you to do, so that doesn't really work. We would just say, what do you propose? And then we would look at that, right? We would look at culvert capacities. We would basically assess what the RM is asking for. Is it reasonable? Is that going to cause any significant impacts downstream from that? Will that help the issue? I mean, if it doesn't help the issue, we can still license it, because it doesn't matter to us that it's not helping, right? We're still issuing the license. Maybe they're taking a chance that they're hoping it's going to help. But yeah, we don't recommend or give suggestions. That's all. Sorry, can you?
I was just gonna say, on the portal, on the website with the maps, does it not show culvert sizes and on that map in certain spots?
It might, I'm not sure. So some things are public and some things are private, right? So we have a version of that map in our own system. And sometimes we can see that information. I'm just not sure if the public can see it or not. I'd have to actually go to that map to see.
Or is it just if it's licensed maybe, or like?
It would just, you'd only be able to see it on the map if it is licensed,
okay,
right? Or if we've provided some kind of authorization for it. There'd be the red dot. And then if you click on that red dot, something I think pops up, it'll say like RM of Hamiota, right? And you'd go for more information, and then it might say on the side like, hey, in 2011 they applied to, they got a license to replace this, or upsize, or downsize, or whatever, right? That, I think that's available on the portal.
I think it's on some spots, but maybe not
yeah.
everywhere from what.
No, it might not be, because some Some information was through our old municipal minor works, and I'm not sure if all that data from all those licenses are actually been uploaded yet to our system. So there might be kind of a little bit of time lag from that old system if it's already been uploaded to our new system.
Is that something that will you continue to update or
Yes.
will continue to be
Yeah.
updated? Okay.
Yeah.
Depending which watershed district you're into, I know that when I worked for the West Service, we did culvert inventories. And a lot of your watershed districts actually have a map with all the culverts because they send out summer students to survey the inlets, outlets, and the sizes. So you can always look at them too if you're wondering about culvert capacities. Because I know
I
Upper
believe-
Assiniboine
right.
has
Yeah.
one.
Yeah, they have
As
quite
well.
the data collection actually for a large area.
And it's available on their website. If it isn't on our portal,
Yeah.
because they have all of them licensed and not. Yeah,
So back to culverts.
Okay.
If you want to put a new culvert in the road, say, roads built in 1940, there's no culvert.
Yeah.
So you go to RM. The RM have to go through you to get the new culvert?
Yes.
Yeah.
Okay, so you're the wheel.
Yeah. You can apply on behalf of the RM to get that culvert. You just have to go to the RM and get something in writing from them saying we are okay with it. The license, we would review that. If there's no impacts, no mitigation measures, we would write the license, but the license would be issued to the RM. And then frankly to us, we don't care who does it. Like if the RM says to you, yep, you buy the culvert, you go do it, whatever, that's fine with us. We don't have anything to do with that. We just gave the license to them. They can hire or not hire whoever they want.
So on a road, what is the average size of a culvert supposed to be?
There really is no average size. It's all gonna depend on the topography, what is being drainaged, the whole watershed. Yeah, there really isn't. I will say for a lot of just typical approaches, we're seeing a lot of the RMs move from the old 12-inch to maybe more of an 18-inch. But that's just a generality, right? I started in 2008, I think, and it was all 12-inch. Like everybody was just putting in a 12-inch, 12-inch, 12-inch. Now I believe it's more 18s if they're just putting in something to make sure that, there's enough water can go through if needed. It won't be a skunk trap. It won't be whatever. They're picking more the 18. But everything else through the roads and everything else, that's all based on
it's upstream,
the
what's
pattern,
downstream,
yeah, the
what's
watershed
feeding
itself,
it.
all that. If there's no other questions, we'd be happy to speak to you individually. If you have concerns about a specific file or a specific piece of land, or if you're looking for an update on a file or something, we can definitely try and look that up for you. We can write down our information or our contact information for you if you'd like as well, or you can always call the RM. They'll be happy to give out Haley's, as she is the officer for this area. But yeah, you can always contact us with questions. Like I said, there's a lot of information on the website if you have questions as well. But we'd much rather you give us a shout and ask us a question about whether can I do this or can I not do this without a license, then we have to come up and tell you you couldn't have done that. So. Yes?
Just maybe make a couple comments from the watershed perspective.
Sure.
We have a lot of information available for you guys. So, like you're wondering about culvert sizes, we have everything. You can find it yourself, we have everything. You can see every size of culvert throughout the entire municipality. You can see the elevations of all the culverts. So, I mean, if you want to do some of the homework yourselves, the information is available. Also, we have mapping that provides us with imagery to show all the class 1 and 2 wetlands. We actually have a program where we pay people to keep them. But if you're interested, we can create maps that show all the 1s and 2s on your land. If that's of interest, just see us at the watershed, or I don't know if Kevin at Ducks, if you guys have that available for them too, or Ian with Manitoba Habitat.
Come up with stuff to
But we all have the technology there for you guys if you want to find.
Yeah, it's all an added benefit, like if you're able to include that in your application, like, right? Like, hey, I've received this from DU, or I received this from the watershed, it's helping me identify that this is a 1 or a 2 or whatever. All information is welcome. We will definitely review it, we will definitely assess it. And if there's any kind of conflict, or, you know, maybe we just want to go out and just double check that that is what we think it is, we will do a site inspection. And if there's any kind of, like if we're contradicting what they've said, you can always bring in a third party. It's usually myself. If an officer has done a assessment of it, I would come in as the third party to try and determine who's more right, I guess.
Just one more question. Years back in the 80s, Lenore had a good program. They did wetland, they had gates. So they had a big sloughs or wherever, and they only let so much water in. In the springtime, in the fall, they opened the gates and let the water go so it didn't affect anybody on the farmland. So can that be done now in RM Hamiota?
Any kind of project, we would look at it. Absolutely. Usually those, in general, those kinds of projects are usually proposed or in conjunction with, say, a watershed, right? Because it's a bigger project, it's about storing water, it's helping with the impacts. Those usually come from the watershed. But a landowner is more than welcome to apply for something like that, but it's usually something that they've designed. They'll get the help of a CET to help them design something, and then that comes to us, and we assess it, and it's good to be built. It's generally dependent on topography, the area of the land itself, like, right? Like, is it being used for something else? Is it, you know, already low land and you just want to hold it for a little bit to help downstream kind of, you know, get the water moving? You can hold it there for a bit, and then, you know, as soon as those culverts are at half capacity, you can let these ones go. Yep, those are projects we've all licensed in the past, and we will continue.
Should roadside ditches that water always runs down every year be maintained by the RM? Like, and I don't mean mowing it and filling it with mowed cattails, it just gets deeper and deeper and deeper. Like, should they be maintained to a set level?
Not necessarily. I
So
mean, that's the
vegetation
RM's
gets-
call. Yeah, that's the RM's call whether they want to.
Okay.
I mean,
We can't force an RM to maintain their ditch either, that is on the
Yeah.
RM. So that would be just something you would go and talk to them about and then come up like,
But would you approve that then?
Yeah.
Or would, like, if they wanted to, just say they wanted to go in with a trackhoe and just clean the vegetation out, right? So it would look black, but you're not taking any depth out,
no,
right?
so.
You would have to approve that first, or no?
So basically, our licenses are issued in perpetuity.
Okay.
So that means that once you get a license, you can do those works anytime you want.
Oh, yeah.
Or however many times. So if an RM they want to clean out the west side of 54 or whatever, and they get a license for that, they can clean that out every year.
Okay.
Or, you know, you've had a flood, maybe they have to clean it out twice a year or something, right? Like, that's, yeah.
they would just have to follow the survey that's submitted with the application that's licensed.
Okay.
Because when RMs do ditch cleanouts, they have to get a 3-point survey, so a point on the road, ditch, field.
And highway ditches are highway owned or RM?
Yes, they are highway owned, and they have their own set of rules.
Right.
And their own set of regulatory approvals that you may have to jump through.
Okay.
So, yeah. Usually if there's any kind of concerns, I would speak to the local, like your local yard, you know, go to them, see who's there. They might be able to give you permission, they might send you to the engineer in Brandon and say, you know, propose your project to them, and they would look at it. Yeah.
Alright, I just had a question. I noticed like water use licensing, so maybe we don't have as much of that here, but say you have a dugout and you want to use it for livestock or for whatever, watering your vegetable garden or whatever. Like, do you have to have a license for that or a permit?
It all
for that?
depends on your use.
So under 25,000 liters a day, you can use without a license. So that's usually your domestic purposes, right? So that's your dugouts, your cattle, your farmyard, your garden or whatever, right? I believe it's 25,000 liters.
Or so many head. When it comes to livestock, I'm pretty sure it's so many head you have.
Yeah, but the domestic is, like, if we're talking dugout or just farmyard usage, it's usually the 25,000 liters.
And so many livestock, like, do you have to apply with that, or does that have to do with your number on your, I can't remember what it's called. Like, how do you let them know how many head you have, or?
Yeah, I'm not, I'd have to clarify that. I'm not sure it is based on that. The only point I know is the 25,000. So that would be, we can, if you want to leave your contact, we can
Okay.
double check on
And
that.
then if you
but-
wanted to clean out a dugout, do
Yep.
you have to get, you have to register that or license that, or what happens if you want to clean it out?
So traditionally in the past, we have said that no license or any kind of authorization was needed. That may change in the future. Right now, we're still going with old past, no authorization needed, but just saying that may change. We're looking at all sorts of types of things that we used to allow, and making sure that they follow our act and our legislation, so.
I do hear your concern about the culverts. The unfortunate part is that we're still, what they're talking about today is licensing. Unfortunately, we're still dealing with the illegal, and probably 99% of those, we don't even know they're happening, right? They're in the back 40 and somebody's drained something, so unless you go up in an airplane and fly every quarter, that's really hard to pinpoint. But I do understand where you're coming from. If the culverts don't match up, it creates a bottleneck, for sure.
But there are engineers with expertise in hydrology that could do a hypothetical design criteria for these waterways so that we know when the culvert capacities are adequate. It's not rocket science. Just like it has to get done, it's not an excuse. I don't think. It should be done. And we, the landowners, should be made aware of it. It's not that complicated. But nobody has documented this with reference to capacities for spring runoff. There's no point in having, for us anyway, downstream, having very good runoff upstream, and we're stuck with the lack of, can't get off our land for 6 weeks. Well, we're not going to be happy with that. Why shouldn't we? That's because the culverts won't let it away. And that's a design criteria that can be documented. Flow rates are not beyond even being measured, let alone culvert capacities. That's common knowledge. The theoretical capacities are out of the book. Practical, real-time, actual capacities are a different story, but it's not regulation and licensing that determines the design of the waterway, but it certainly should be a criteria if somebody says, I want to increase the flow on that waterway. If you don't know its capacity, how the hell can you answer that? Beats me. I don't know. That's my concern. We need to know capacities and
So we should do kind of a drainage,
fix it.
a drainage study kind of thing on, not necessarily saying we're for or against drainage, but we should at least know what we're talking about. Is that what where you're coming from?
We're not against drainage, we're
Yeah.
against holding water for all our people. If the water comes through your land, no problem, let it go through your land, but don't keep it backed up. Get the problem sorted down south.
Talk about prescribed wetland. I don't want somebody to prescribe mine's gonna be a wetland because the culvert can't get away. I need a vote on that, or at least a voice on it.
Right.
Just because the culverts can't get away doesn't mean I become a wetland. I don't see that, but it's
But I also think there's neglect in some of the waterways that the RM owns haven't been cleaned out, and the water can't get through, and that's part of the problem, as well as the culvert size.
its capacity, and that's not meant Not like it's an exercise.
If I have a high knoll on my land, can I take and remove that into a low spot without a permit?
No, unfortunately you can't, because that is considered filling, and that is a water control work. So it would have to be a licensable project. And so my advice to you, if you're putting in a license, you might as well do anything else that you're doing on that piece of land as well. So you're paying $500 for all your works, not just one work. Because like we said, the license is issued in perpetuity. So if you want to put something down that you might do in 2 years or you might do in 5 years, we might as well put it down. We can license it now, authorize it, and then you have that authorization in hand when time or financial or whatever allows you to do it.
What does this $500 go towards?
The $500 goes towards basically us assessing it and making sure there are no significant impacts. The licensing part of it, yeah, but it's mostly the assessment and the review of it. That's the cost. Yeah. And a site inspection if we have to do it as well. If we need to come out and see stuff. So yeah, that's part of the cost as well. If there's any more questions, we're good, but we will be here for a bit, so if anybody has any specific questions or want to talk about their files, we are more than happy to stick around and chat if you want. And we'd just like to thank the RM for inviting us, and we hope we've been helpful in providing you guys some information. But if you need more, we're always available, and to give us a shout.
So like I mentioned at the start, if you have specific questions that you want to talk about, like Ingrid said, they're going to be here for a little bit, and so you can pose those questions to them. I've heard a couple here that are in specifics, so bring them forward to them. Thanks everybody for showing up.